back on the darkness, stare down deceit. Murder in the headlines, justice in the beat. From cold case whispers to killers in disguise, we rip off the mask, expose all the lies. Facts like bullets reload and deliver. Truth cuts deep like a blade in a river. Corruption shakes when the mic goes live. We dig where others won't survive. James rolling through the smoke. Truth hits hard, no time for a joke. Deceit, murder, we name every name. No restraint, no shame, just flame. Locked on the case, we investigate. Cold files heat up when we penetrate. The only source you'll ever need. 12 gauge investigate. We make them bleed. No games, no censors, just truth. Justice is loud, and we're the sound. This is 12 gauge investigative.
This is 12 gauge investigative. Let's jump in.
Happy Sunday, everybody. How's everybody doing this morning? I hope you're doing well. My name is 12 Gauge, and this is my channel, 12 Gauge Investigative. You know, this Sunday morning here in Texas, it's quite warm already. It's already about 86, I would say. So wherever you are, I hope that you're having some wonderful weather and that this heat wave isn't affecting you in any way, shape, form, or fashion. I thought I'd hop on here and take us back to the hearing and even play a little bit of the hearing to discuss it. Because, to be honest, the first time that I watched this, I was doing it live. So I was having to stop, start. And I wasn't able to really listen to what was being said because I was too worried about stopping in the allotted time and not getting copyrighted. You know what I mean? So the second time around is always a better thing because, awesome. Yeah, it's a beautiful morning to be watering. To be able to watch it the second time around, you're able to listen and hear more. And especially now that we got the documents out here, you can definitely understand how it went down in this hearing. So, of course, there will be another one of me in the corner right here. So don't get confused. I'm still with you. I just need to fix this a little bit to be able to present this. Hold on a second. I'm trying to get it situated. Don't necessarily need another person right there. Guess we'll put it right here, just like we're watching TV. And like I said, the first time around, it's different because I was too busy worrying about other things. Here we go.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Bryan Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically,
okay, I forgot to say that fair use thing. Well, everything that I'm commenting on is due to my impression of this hearing and it's covered by fair use, and it's being used for nothing other than educational value. So everything that I comment on this ABC,
We have talked about the discovery, rights to confrontation, his rights to a fair.
just for that. So here we go. Ann starts off first.
A continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Koberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have
And to be fair, the defense does have a uphill battle. They have an uphill battle to be able to decipher all that terabytes of data and everything that's been given to them in discovery wise. I understand that. But at the same time, as Hippler has stated, she has never asked for time. She had just hinted around possibly needing more time. There's a difference in that. You know what I mean? Hi, Kathy. How are you doing? Judge Hippler's had a month to read this motion filed May 20th. So she's going to go on and talk to us about exactly Brian's right to a fair trial.
talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge.
Okay, let me start off by addressing the discovery, okay? I know that people think that she is still not getting discovery from the state. You know, whenever the state hands over discovery, in this case, they had a deadline. And they're not still handing over discovery. When she said, I just got discovery this week that I haven't gone over, I'm sure she meant that due to the people that are putting it in order, that's why she hasn't gone over it yet. Not that she hadn't gotten it from the state. The state had a limited time to give this discovery over, and they handed everything over by the deadline. So when she said, I barely got new discovery this week, that doesn't mean that she just got it from the state. It means that she just got it from whoever, and I hope that makes sense. I mean, I am going on a whim here to believe that what I'm saying is accurate, that she is going over the discovery in a sense that she has received it from her team, you know, to go over to incorporate it into the eventual trial manifestation, you know, to be able to discuss it in the trial. And when she said that she barely got it, it's not necessarily meaning, as my understanding, that she barely got it from the state. It's my understanding that that's the first time that she's gotten it from her team in a readable, legible way where she can put it and incorporate it into her trial manifesto. She has going through the discovery and putting it in order and everything that she's talking about. So, you know, it's a play on words, obviously. It's a play on words, like what I talk about, the semantics.
Huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023, and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there.
Do y'all understand what I mean by that? It's not that they're not getting or have the discovery already. As she's speaking right now, they've yet to go through it and put it in any kind of order that's going to be usable in the trial. So let me mute myself whenever I'm talking, because that kind of aggravates me a little bit when I'm hearing myself talk. What do y'all think as far as so far that we're talking about this? Do you believe that she's really as behind as she's presenting? I mean, understand she has another death penalty case, but do you really believe that she's that far behind that she doesn't have any type of manifesto ready for the trial, at least? I mean, even the opening arguments, even some of this stuff. Do y'all really believe that, or do you think that she's buying for time? You think she's buying time? Let me know what you think in the chat. I believe that she is buying for time, not because she's incompetent, but because she has a lot going on in both of these cases that she's trying, you know. She has the other death penalty case plus this one. But I don't understand why the delay, and I've never really understood it as being a tactic that would be working. I mean, it's worked thus far, I guess, but to continue it would show a little bit of incompetence, it would seem. There should have been multiple motions to compel discovery. I agree with that. I do. She just did not do what she needed to do early enough. I mean, I guess she thought that she was going to be able to get the continuance, because last hearing she mentioned it toward the end, and she said, well, you know, Your Honor, we're still struggling a little bit as far as getting all the witnesses to speak, all these individuals, blah, blah, blah. And she's hinting, and she's hinted all the way around, but she's never come right out and asked for anything to be done about it throughout the whole time. And I think where she messed up with the continuance was the indefinite time frame that the documents were talking about. The indefinite time frame. You know, had she given them, you know, we might need 60 days, a month, whatever. I mean, then it might have turned out different. But the fact that it was indefinite, there's no end in sight, then the judge was like, okay, well, I'm going to put an end to this, because there's no deadline for us to be looking forward to this trial, that she'll be ready by this point. And that, I believe, helped him make that decision rather than assist the defense. And, you know, she should have given a definite timeline. It just to tell the, okay, she has stopped.
Presented in a motion that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom.
Well, wasn't it them, the defense, that even filed for a change of venue? How can you file for a change of venue based on an unfair prejudice of your client not being able to get a fair or unprejudiced trial in Latah County? It gets granted to you. You go to Ada County, and then you're griping because you had to go through that when you're the one that asked for the change of venue. Did they not, chat? Am I wrong there? Does my memory fail me whenever I'm thinking back about the change of venue? Was it not the defense that asked for the change of venue due to, people potentially burning down the courthouse, storming the courthouse, and potentially beating up people and all that? I mean, to answer your question, Leslie, the judge is not swayed one way or the other. The judge's job is to maintain order and make sure that both sides don't break any laws leading up to the trial process. They don't have one horse in the race. They really don't. I don't believe that Hitler is one side or the other. Just because he denied a lot of the motions, there's been explanation for the denial. So it's not like it was just denied without any kind of explanation whatsoever. You know what I mean? So I don't believe that he swayed one way or the other. This other stuff, is that not what was said? That's one of the reasons why they wanted to change a venue. Just correct me if I'm wrong. It's cool. I'm not above being corrected.
We discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and request for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to read.
So, chat, how do you feel while this is playing? I'm going to let it play, but as you know, I keep shutting it down because I don't want a copyright. I don't want the screen to go black, okay? How do you feel about the defense asking for more time? I've never really heard y'all's responses on that. If you could type that in the chat, that'd be awesome. I'd like to hear from you.
Review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright, 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed. And that comes from State versus Creech, 105 Idaho, 362 at 383.
I agree with your answer so far because, yes, he did say at the very end, prepare to go to trial on the date that was given. And also, it has been 2.5 years. You're right, Farah. You're right. 1 month and 23 days until, the fact that it did take so long for this trial to finally get here, I believe that at this point she needs to kind of go and get her game plan in order, because the judge told them from day one, I expect you to be professionals. And she even mentioned on that first or second hearing, once they moved to Ada County, that, she had so much to go through, so much to put put in order and stuff like that. And he said, well, there's 24 hours in a day, 7 days a week. I mean, that pretty much told her at that point, he put her on notice. You know, I'm not going to play with all these delays and all these, you know, motions for continuances and all this stuff. That put everybody on notice. And in the documents, we did see some of the arguments that have facilitated this need for a continuance throughout the process. One was the defendant felt that he had an unfair advantage because they didn't have the same type of program that the state had, and therefore it made their job a lot harder, which is true. You know, it is an uphill slope. But you know what? If you don't have the people to do it, you need to hire the people. I mean, cut into your salary and hire these people that you need to get this going, because this case is not going to last forever. And I believe that had she done that, they'd be ready. They'd be ready. You know, she could cut into her own salary of $200 an hour and hire some paralegals to get things in order for her, you know? Trial. That is, you're not counting down, are you? You're not counting down. Good to see you. Good to see you.
Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. And effective assistance of counsel applies both to the merits phase and the penalty.
Okay, effective assistance of counsel. So is she saying that they're ineffective because they don't have the time to go through all the evidence that's been presented to them? So that makes them ineffective? I mean, that'll be discussed at the appeals process if he is found guilty. You know, that could be something that they throw in there. I mean, I just don't understand what has been the holdup on the defense's side, you know? And honestly, they don't have to prove his innocence. They don't. They just have to prove reasonable doubt. What is so extraordinary that they're having a hard time putting together a game plan to put reasonable doubt out there? You get what I'm saying? The state had the burden of proof. So what is the defense's making it sound like they have all this stuff that they need to prove his innocence, and they don't have to do that. All they have to do is show reasonable doubt. So I don't really understand why the time frame is so imperative. I'm glad that we didn't get the continuance, but at the same time, it's been like this for 2.5 years, and it's the same song and dance. Tell me what y'all think about this, because I'm merely playing it for the chat, not for myself. I've already seen this. What do you think about her presentation? Do you believe that she's strong enough when trial gets here to advocate for her client? Because it's not going to be about innocence or guilt. She's just going to be advocating. Do you believe that she's strong enough to advocate for her client? There was too much time, in my opinion, on a doomed alibi defense, which never met the requirements by law. Yeah. Well, have fun, Leslie Watering. Seems like to me the leaker may be untouchable. In my opinion, defense also blew a potential wannabe suppression motion of failing to argue standing.
Phase of a death penalty case. The courts are guided and counsel's guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith 539 US 510 at 524 said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 said relies on the ABA guidelines as the proper measure to test an attorney's investigation.
Can you imagine sitting there listening to this and knowing that the state has already addressed this? You know, knowing that the state has already sent a motion addressing this, and their document is more credible in the sense that it has different reasons why you should go to trial versus what they present. How even what she's presenting right now. Yeah, I've heard that he's done a death penalty case before, so I don't believe that this is his first one. He was placed on this case from the Supreme Court, so I don't believe that that would be a motion for appeal, but I could be wrong. There's an under seal defense motion for an investigation that might be about Dateline Gate, as we call it. I'm speculating that may be raised during the week-long hearing. She's in over her head, public pretender. I mean, to be fair and to really be fair, she has only what she has to work with. And in her line of work, it's all about protecting her client. He's facing death. Her line of work is to protect him to not get the death penalty. Maybe get life. You know what I mean? So she has the job to dig in really deep and try to do that for him, to save his life. But at this point, I believe that she's ran out of options unless she brings a good manifesto to the court trial. If she comes at it like this, I don't believe that she's going to come across to the jury as convincing enough. She needs to be stronger with her words and more assertive. You know what I mean? Yeah, it's a win if she gets the death penalty removed. So she's not going for innocence per se, but she's trying to save his life. And that's the biggest obstacle at this point. It's not really about innocence or guilt. I mean, if she gets the death penalty removed, then she's done her job, The prosecution stands up there and rebuttals everything. And without reason, she doesn't give a very good presentation on the reasoning or how long they need for a continuance. Because I was thinking the same thing. I'm sorry about my phone going off in the background. I keep looking at my phone right now. I was thinking the same thing. You have not given any reason as to how much time you need. What do y'all think? Am I right here? Did she not give any time frame?
In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation.
Yeah, I'd said that right there, that she hadn't given a plan to get to this point. Okay, we need a continuance for 3 months, or we need a continuance for 6 months. She didn't give any of that. She was just up there just spouting the reasons. And if I've learned anything in working in the judicial process and everything else, I'm not a lawyer by no means, so I'm not trying to pretend to be. But I know that everything comes with a problem, plan, eventual solution. You can't just put the problem out there with nothing else after it. You can't speculate. It's almost like they're showing more of the problem than the plan to get to the solution, because if there's not a plan, then there's really no argument there. You know what I mean? Because you haven't given the court an avenue to work towards.
Investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Kohberger's background has to be known and investigated and ready to.
Do y'all remember when I went over the state document where they were talking about they've gone to the Supreme Court, and there's different cases where one of the cases says you're not supposed to, they don't want you to scour the earth for every little bit of life history before you go to trial. And I agree with you, Farah. I really do. Why would Ann Taylor take on another death penalty case if she's having trouble meeting the deadlines for this one? I mean, she says she doesn't have a lot of time. Head of Christ, thank you so much for coming over from X. Good to see you. Anybody from X, feel free to come on in the chat. You're in a good place. You're in a good, safe place. So come on in and chat with us.
To present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information.
Okay, let me ask you guys a question. I don't know if I say this in the coming, video, but do y'all believe in scouring the earth for every little piece of information on a defendant? Not just Kohberger. I'm talking about any defendant. At what point is too much time spending on generational makeup of their mental health and anything that goes along with who they are as a person? I mean, even if the guy's not going to, he's not going up on the stand. So, I mean, I believe that that's more toward the penalty phase, if I'm not corrected. But do y'all agree that there should be a lot of time put into, like they say, scouring the earth for every little bit of detail about this defendant? What do y'all think? What do y'all think? Let me know.
We do have several experts that would be ready for the mitigation portion of the case should the case reach that phase. And they rely on understanding family history and Mr. Kohberger's own history. They can only understand what they've been presented. And the investigation to fully evaluate needs to be thorough.
So let me ask you, she's talking about being thorough on his life history. He was only 28 years old when he was arrested for this crime. How much life history does it take to go through somebody's 28 years? At least the first 5 is all about, birth, any kind of childhood issues, and then all the way up until 28. You're telling me it takes you more than 2.5 years to go through the life history? I don't fall for it at all.
That means that records have to be collected. That means that interviews collect.
And I've also said in the past in some other videos, he went to rehab at 14, 15 years old. They would have done a complete psychological buildup on him. They would have done assessments, screenings, personality traits, all this stuff. If he was diagnosed with anything at that point, it would have been in those records. It doesn't take no time to get those records with the consent from the defendant, and boom, you have it. The same thing, if he was going to any outpatient counseling, the same type of stuff. So if he went to the doctor to get some medication, any of this stuff would have been available. So it's not like they got to do a complete life history makeup. I mean, they do, but think about this as well. They do a psychological at the very beginning to make sure that you understand the charges that are against you, that you understand the process of what's going on, why you've been arrested, what's going on, what you're facing, all this. That way, you can't move forward until that person understands and is culpable of awareness of what he's facing, he or she. Because you cannot hold somebody if they're not mentally capable of understanding that. So I'm pretty sure that they did that as well. So how many psychological buildups or makeups do you have to have before you have everything that you need on this individual? Also, if you interview the family, there's going to be a lot of information there. I mean, I just believe that either she hasn't had the time to do it or she just hasn't done it. Because not everybody is proficient at their job, no matter what. She could be a hell of an attorney, but she could suck at paperwork. And that's usually how it works. Because I've worked with people that are hella therapists, but they suck at deadlines, they suck at paperwork, they suck at, making sure all the I's are dotted, the T's are crossed. I've worked with a lot of individuals like that. They're very proficient in one area, but when it comes to paperwork, man, it's a wrap.
Collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation.
And you've heard me say countless times, there's nothing wrong with being thorough. It is a death penalty case. I get that. There's nothing wrong with them going to above and beyond, trying to find out if anything could set this man free when the trial comes. But at a particular time, when your attorney has a pattern of stalling and stalling and stalling, you have to speak up on this, because at this point, that's what it seems like. She hasn't mentioned any of this stuff. And they did the the last hearing where they were getting ready to go to trial. Nothing was stated about this. They were dropping the alternative suspect thing. They were dropping all this stuff just to stall. Do you believe that they actually have an alternative suspect? Do you believe that we're going to hear that this alternative suspect Is somebody viable or something viable enough to turn the course of this? Or do you think or believe that we're going to go to trial?
They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's.
And you know, she did that in Latah County where she was saying there's over 400 potential leads that I must investigate. People are having trouble talking to me. They don't want to talk to me. I can't get in touch with certain people. We can't find certain people. So she said that from way back, and nothing's ever been addressed about it. But she's counting on, I guess, this being a situation that ultimately gets addressed in the appeals process.
Imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Kohberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage, the Dateline issue that has been talked about in this courtroom before, and what's yet to come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything.
I agree with that wholeheartedly, Kathy. I really do. Because it does seem like they have spent so much time on everything but preparing for trial.
That happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 330.
You know, I've heard that throughout the whole process, and I know y'all have too. The fair trial, fair trial, fair trial. But it seems like his defense has not prepared to go to trial. It's almost like she's more worried about all this sideshow stuff than actually preparing for the trial. One thing I have to ask you, Kathy, because I don't know a lot about the attorney stuff. If he is convicted, will she stay as his prosecutor? Will she stay as his attorney, or will he get a appellate lawyer? Can you answer that for me?
33.
And if she's watching YouTube and speaking about who keeps talking about it, who keeps talking about it in a negative light, who keeps talking about the Dateline episodes in a negative light, where it could potentially sway the jury's rendition of whether this guy was innocent or guilty. Do you believe that, you know, honestly, people really sit around and talk about this case outside in the real world? Let me know how many of you actually have heard about this case in the last 2 weeks. How many of you have heard about the Dateline episode in the last 2 weeks? Has it continued to grow, or has it kind of died down? Because, you know, on these YouTube streets, I really don't hear a lot about anything until it drops some kind of video. The hot topic this week is the DoorDash driver, the friend of Brian's, whoever the hell he was, those type of things. How is that going to impact a jury, honestly? You know, the Green Elantra. How are those things actually going to impact a jury's mindset?
And a continuance may be the way that the court can best protect Mr. Kohberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode. That's not all. There's a book set to be released just a few weeks from now to be followed by a docuseries on Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in.
See, nobody would know that if she wouldn't have said that. Do you get what I'm saying? Nobody would know that who's testifying until she said that. And some of the people in these docuseries are going to be witnesses testifying. Well, I understand why she said that, but she releases a lot of stuff that people don't need to know. If it was not released, it would be unknown, and there would be more chance of a fair trial than her just blabbing her mouth like she does. And that's just my opinion.
The docuseries, at least, and maybe noted in the book. That is, in and of itself, an exceptional reason for us to have a continuance to let those things play out.
Okay, so if Hunter and Emily, obviously that's who she's talking about, amongst others, actually participated in any of this stuff, are they going to represent anything that they already haven't got on record with the police, with the investigators? Because unless they go against their narrative that they gave to the police, then there's nothing wrong with them speaking on what they're talking about. How is that detrimental to his rights? I mean, it's a public right to be able to hear what this defendant is facing against him. We really haven't heard that much stuff. We hear it on YouTube secondhand, where we're forced to be getting different perspectives, not from the narrative of the news per se, but from YouTube channels who have an agenda to try to slander and manipulate the facts to be one-sided.
Out for a while. I would also note, Your Honor, that jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Kohberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
I mean, to me, it just sounds like she's defeated already. She doesn't have that. She's not bringing it like she was in Latah. She sounds defeated. Like, okay, I know we're going to trial, but I got to go through this motion. I know you're going to probably deny this, but I still got to give it my best shot.
May I, Your Honor?
Of course.
Thank you, Your Honor. I will, I think, address Ms. Taylor's arguments sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to.
I didn't watch Karen Reed, but based on some of the stuff on the first trial, I would have thought that it would have been harder to get a jury that hadn't heard about the first trial, but they were able to get a jury on the second trial. And obviously they did their civic duty today, and everything went along just fine, right? Unless that's not the
Happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction.
Leslie, to answer your question, I thought she was pregnant, so she may have had her baby. I don't know. I'd heard that she was pregnant. I don't know if she was or not. This attorney is arguing counter against what the defense attorney just argued for. Obviously, the prosecution didn't want a continuance. He's talking about, how they're discussing certain things and how the state is counteracting that.
The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
Clark needs to switch it over.
Okay, thank you. So these are cases that we cited in our brief, and I wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a stand.
Yeah, that's what it's called, scorch the earth. That means like you don't scour the earth for every little bit, nook and cranny, hiding out, looking for every little piece of information about your defendant. I mean, it's honorable, but it's not necessary.
Standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had.
See, that's one thing that she's delinquent in that I've noticed in these hearings. Like I said a while ago, she's not very proficient in giving solutions. She's about the problem. We need more time because of this. But this would be the solution and the reason that we need more time. But she doesn't ever do that. So that's, I believe, is why a lot of the motions have been denied, because she doesn't outline a plan of action. And that's what basically you just said.
When this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial.
And that is true. He makes an interesting point there. It's not a checklist. It's not like, you know, if we go in this direction, checking these off, then we're meeting the legal criteria to go to trial. But it's not that way at all.
Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, there is no basis for a motion to continue. Now, let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established, or maybe even modifying them as the court wants to, can seat a panel of impartial jurors.
Yes, I mean, they've gone into detail. The judge was talking about this on the last hearing. These are the steps he's going to take if he needs to do this. If the publicity becomes too great from only allotting so many people to go into the courtroom, only allotting one local journalist to be able to be talking about the case. I mean, he's gone above and beyond to make sure that what he's talking about, what's going on in that trial, is not leaked on a daily basis. You know, he spoke about it last hearing.
The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place, if there's a continuance. What seems to be the strategy here is just to delay. And that leads.
See, I think that's going to be the huge point right there, that she didn't give a contingency plan on how they want the continuance to go. Like, hey, Judge, we're asking for 60 days, and this is what we're going to be working on in those 60 days to get up to speed so that we can get to trial at the time that it's needed. I didn't hear any of that stuff. I don't know if I didn't just hear it or you guys heard it, but let me know exactly what you think, you know. Do you believe that she could have done a better job at a contingency plan, presenting it? Most of her arguments, apparently, they seem very emotionally connected, emotionally based, not so much on the law part of it. Hey,
Leads me
Midwest.
to, I think, the other point that Ms. Taylor raised, which was to say that, this shouldn't be a surprise. It is a surprise to us that a motion continue was made so late in the game.
I mean, one of the things that I was going to say earlier is, we have individuals, when these documents come out, they believe that Hitler makes the final decision, which he does based on case law, based on how they have been solidified in the past due to case law. So when he made the decisions on this, he was doing it based on prior cases that had to litigate these type of issues. So it's not like he sits down and says, well, I'm going to make the final say based on my emotional attachment to this. It doesn't go that way. There's a lot of individuals that state that lawyers are corrupt, judges are corrupt. But all you have to look is in the documents, it's the case law. And go read the case law, and it will tell you exactly what has been argued over and what was the final result. And when the judge goes to review these motions, that's what he's basing his decision on. Is it more case law imperative to go towards a continuance, or had this already been fought out all the way to the Supreme Court? And is this what the Supreme Court ruled? So I can't go against the Supreme Court ruling. If this is going to be the highest court in the land, you can't just say, well, I'm going to make a new president and I'm going to go against the Supreme Court. I guess he could, but I mean, not many people are going to do that. You said 100%. In my opinion, the issues raised on the page 32 should have been front and center on page 1 and framed as Judge Hitler admitted his impact due process. That was the major argument. Yeah. I mean, there's so much that goes into this that people really don't understand. They think, like right now on that screen, you see him leaning over with his hand on his face. They read that as he's bored, he's already made up his mind, whatever. We don't know, but I would bet that he's trying to pay attention to what is going on and what's being said and trying to articulate everything, because you see him taking notes.
After, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense, until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record.
You're so right. You're so right, Barra. I didn't catch that the first time. You know, it's like, oh my God, this guy's on point. They got a superstar up there. Brian looks a little stiff today. What's going on, Brian? Didn't stretch?
And ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history.
I mean, I'm no expert, but I believe that she should have dropped the motions before they did the formality of the hearing that went into what's going to take place at the trial. Had she dropped it before then, she might have got her continuance. But this is like the last minute thing. And the same thing he said about the alibi. We don't want that alibi to be dropped, or a different alibi to be dropped at the last minute, because there's no way that we can investigate that. There's no way that it could even be looked into. So I believe the alibi they're going to stick with is he was out stargazing. I've never heard anything different, so I don't believe that they're going to be able to drop anything different at the last minute. I mean, there's rules to be going into trial. There's protocol. There's all these things. But it, like you said, Kathy, you know, it seems like she doesn't listen to Hitler. He tells her exactly what he wants, and she doesn't seem to want to do what is being asked of her as an attorney.
History investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete, and the experts didn't say we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have a life history for the defendant. The defense has amassed significant materials, and I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuation.
Yeah, someone said his name was Josh. So I don't know what his last name is, but I remember hearing about him. He hasn't really spoken the last two hearings, but it's good to hear him talk. I mean, he seems like he's very knowledgeable on his stuff, and he's not really aggressive, and by no means. None of the prosecution has came across as aggressive or mindless or any of the stuff that is repeated on these YouTube streets just because they have disdain toward the state. I mean, they have a job to do. You know, this guy has been suspected of 4 murders and a burglary. They have a job to do. To pin these two sides against each other is just for theatrics. To pin the judge against Kohberger is just for theatrics. You really think the judge is up there looking at Brian going, God, I can't wait to sentence him or till he gets sentenced to death. Do you really think, honestly, professionally, ethically, he's doing that? No, he's not. I mean, to hear all these things that are said about these people, it's just ludicrous sometimes.
Continuance, and to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
I believe that was presented well. I don't believe that he went outside of any guidelines. There wasn't any kind of, like the judge said, there wasn't any kind of theatrical going against the defense, any of this stuff. And honestly, to be honest, on the defensive side, Ann hasn't really done any of the stuff that she did in Latah County in a while. She has stopped with her theatrics. Now she's gone to the solemn, almost sad mother sympathy card to pull on the judge. You know, like, come on, judge, you know, we need some time. She's pulling out all the stops.
Can you reply?
I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records, Bryan Kohberger, past treatment records of Bryan Kohberger.
And there's only one way to overcome that, is to get a consent for release of information due to HIPAA laws. I mean, there's an easy way to get through that. They're not going to speak to you because they can't tell you anything. They can't tell you anything due to the HIPAA guideline. Get the consents from Kohberger, have him sign, specify what you're looking for, fax it over to them. I'm sure they'll send it your way. You may not be pleased with how things are going as well. Body language speaks volumes. You're right. You're right. He's been sitting next to Ann, and now he's next to Massoff. Wow. I never noticed that before. Thank you. Good catch. But that's how you get around that. Because the HIPAA guidelines, they're not gonna release anything without consent from the individual seeking the information. I mean, she could get a judge order. She could get, you know, as an attorney, she could draw something up, have Kohberger sign it, get the information. It's difficult, but it's not difficult whenever you're looking at it in a trial basis. You know?
Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information. Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Bryan Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Bryan Kohberger's full life history.
You know what? When it comes to trial, be ready to see Bryan come in with some glasses and obviously dressed to the nine, because it's been a tactic that I've heard from defense attorneys in person say that they tell their client to look as studious as possible when they come to trial. Put on the glasses, get a haircut, stand up straight or sit up straight, answer the questions, in your adult voice. Don't deviate from anything if you are
Get
put
your
on
eyebrows.
on the stand.
Get your
And that
eyebrows
leads me,
trimmed. Get your eyebrows trimmed. How many of y'all believe that she's doing a good job? I want to know from the chat. Do you believe that she's done a great job defending this man? There's really no right or wrong answer, but do you believe that she's done a great job defending him so far? Leading up to the trial, do you believe that she has what it takes to take him over the last little stretch? Let me know what you think. I mean, because we really haven't heard anything but rebuttal from the state. But do you believe that she's done a good job representing him? Do you believe that, he could have done better with a different lawyer? I mean, do you believe that she's gone above and beyond for him based on what we know about these hearings? We got one negative. Can't judge. I'm not a lawyer. Okay, fair enough. I need to ask you this question. Do you believe Brian's going to testify on his behalf? Who in their right mind would put Brian on the stand, honestly? Do y'all believe he's going to testify on his behalf?
These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years
In federal court,
in federal court.
which moves at a snail's pace in its best day in regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Koberger's team did not delay in getting experts to help us understand.
I did speak on that, Firefly, very briefly last night. I did see the small interview with lawyer that I'm sorry. And I saw what he said. If he was, I mean, it's interesting to me how he talked about the Koberger case and how he knew more about that case than any other ones. But then he said also helped solve a quadruple homicide with the SIM card of a vehicle. But as we all know, if that's true, there must be a hell of a different SIM card in the vehicle that we know nothing about, because most of us have done some deep diving into that Elantra. You're fine. And we've not been able to find anything about a SIM card. The only thing that we've been able to find is about the navigation system part, but it didn't look like Koberger's had a navigation system on his in his Elantra based on the traffic stops. So
Um, it does sound like that. I didn't watch it all, but I saw it a little bit, and I was thinking to myself, it's the Blue Link system. Okay. I've never heard of that. I mean, like I said, if it's something that obviously people have been trained to look for in vehicles and stuff like that, then that could be the smoking gun. You know what I mean? So I don't. That's as far as I know about it. I mean, I hope that if it is legit, that he quit talking about it because everything they talk about is just kind of like releasing the game plan of the state or prosecution. You know what I mean? One of the defense witnesses from Commonwealth of PA is associated with a car dealership. Curious to learn if this is where Mr. Koberger purchased his car. I have let's go ahead and turn this off. I'm going to show you what I have as far as that little aspect because I do I do have the bill of sales. I hope you are doing wonderful this Sunday morning. I woke up getting ready to go to the gym here in a little bit. Um, but I thought I'd do a live first because can't just wake up and go to the gym. I can't do that anymore. I used to could, but not so much anymore. Let me see if I can find this. I like that you brought that up, Kathy, because I was looking at this documents that I have, and it does show the bill of sale. I believe it does. Oh no, we're gonna go through it anyways. This one is the title. I know y'all probably can't see that. Hey, common sense. I don't know how to make it bigger. Let's see if I can do. Okay, can y'all see that a little better? I know it's still kind of small. This is the one that says title regular cover sheet Hyundai. It has the vehicle ID number, his name. Let me get to the next page. Hold on a second. Looks like I'm having technical issues. Let me refresh it. God, the hell? Man boobs. Okay. One of these is the bill of sales. Come on. Well, this is the title. Would this be where it would show where it was bought? Here's the title. It's not. Sorry about taking y'all up and down this page, but the only way to do it. What the hell? I apologize for this. Maybe I will get the right document here in a minute. See, Nina, you're not the only one that has issues. Just got to stay calm. This isn't as easy as it looks. I mean, I'm scrolling, but yeah, I mean, I can't control the technical difficulties. Okay, it's not the title. Maybe it's this one. That's the odometer. Licensing. Whoa. It's a driving record. I'm sitting here looking at this by myself. Hold on a second. Sorry about this, guys. I'm sitting here looking at this by myself. Um, Hold on, let me go back one. Okay, that's not the one. Have to have odometer reading. Maybe I don't have it. I thought I did. It looks like it was bought April 20th, 2022. Is that correct? Is that correct? Have y'all heard that he supposedly bought it April 20th, 2022? So he would have bought this right before he moved to the Pullman. If that's true, there's his signature. And this is when he got the new plates, I believe, 11/18/2022. There's the famous signature right there. I don't think I have the Carfax. I don't think I have it. This is all I really have because I found it on this page. Yeah, it says 420. And it had 101,515 miles on it. Maryland was the prior title state. The date PA titled it was 6/7/16. This would have been the original one. And this would have been when he got it, 4/20/22. I don't know if that's correct or not. The hearing of the witnesses from Commonwealth of PA tomorrow, June 30th. You may learn more about what material information they have. So what is it? Carfax. Okay. Let me get the VIN number. Can you do Carfax without paying for it? I've never done a Carfax. Y'all hold on a second. Don't go anywhere. $5 NPD. H4AE. $6FH5. $79860. Damn. Y'all want to send me $45? I'll do it. Other than that, we got to go with what we got. It's $45 to run a Carfax. So if y'all can come across a Carfax report, let me show you. So tell you I'm not lying. Somebody super chat me $45 and I'll run it. You see it? Yeah, $600, right? $1,600. And then they said this is a good deal. Or send me $60 and we can run two of them, or 109 and we can run four. So you tell me what you want to do. Hopefully we'll find the Carfax that somebody has done already. I think Jeff and I were talking about this one time, and I think he had ran it once, but he didn't get any screenshots or anything. So yeah, you can't have a free one. I wish we could. But I'm sure somebody has that Carfax information out there. Maybe Nina has it. Maybe I'll get with her and maybe she can find out. But this is interesting to say the least. I hope Ann really gets on the ball because we'll really if his car had BlueLink, it had GPS. If not, then no. I mean, the only thing that makes me wonder is about that photo. Let me see if I can pull that up. The photo of when he's in the car with his dad. It doesn't look like his car has GPS on it. It looks like a very basic model. Hold on, I found it. I'm just trying to. Let me show you guys. See, it doesn't look like he has a screen for GPS. It just looks like I used to have a Mitsubishi Eclipse that had this little area right here, and it had the CD player, and that was all it had was the radio. It didn't have any kind of touch screen or anything like that. I don't know if y'all can see that. Let me see if I can save it. That way we can. Let me get a JPEG. That's not a good shot. Okay, let me see if I can zoom in on this. That's as far as I can go zooming in on it. So as you can see right here, it looks like just a little clock area and it has a radio. So I don't know if it really has GPS or not. I already did, Leslie. I already did. BlueLink is similar to OnStar, if you know what I mean. It's above the mirror. Hit the thing. Okay, I got you. Okay, I got you. Most of them do have that, though. Jeff says, I seem to remember looking in the GPS package that could add to an launcher and it came with a 7-inch screen. That's what I think too. That's what I thought too, Jeff, that most of them that do have, that would have had the GPS portion on it would have like a screen, or you'd be able to do the plug and play like I have in my truck. I mean, I have GPS, but my radio um acts up most of the time, so I got a plug and play. The most New York cars, and you do not have to have the subscription for it to be active. You're right. I mean, maybe somebody can look into this photo and see if you can zoom in on the rear view mirror. I don't even see it in this photo, and I'm looking at it right now. Oh, there it is, right there. But I mean, it's hard to see. It's pixelated. You really can't see a lot. This looks like a very basic Elantra. I don't think it's that's what people think as far as an extended, like a luxury vehicle. Because I mean, he would have a screen right here that would be showing the GPS coordinates for sure. Well, I understand what you're saying. I mean, if he had it, it'd be in the rear view mirror portion because that's usually where the OnStar is as well. But it's hard to tell, you know? Hard to tell in this picture because it's pretty pixelated. Why don't I just email you this page and it has all the stuff on it and you can go through and look it up. I don't know. Cars are so fancy and computerized, you just don't know anymore what all they're capable of doing. You know what I mean? Like, it's very interesting though if there is a SIM card somewhere in that vehicle to track it. Because if it was tracked, then the phone's not going to matter. And that's pretty damn scary for a lot of us. I mean, I never knew that even offline, Spotify is still reporting a lot of stuff to the servers. I never knew that until I was reading about it one day. So if you have Spotify, even if you don't have service, you're still able to play music, right? So that's why you can do that because it reports it. You're playing it from the server, not necessarily the web area that. Okay, Leslie, I just sent it to you. Did y'all know that Spotify had that feature on it? Yeah, but remember the ACU data didn't convict Karen R. I don't because I really didn't follow that case that closely, but that's an interesting statement. I don't I don't know that about until some free. I think it said something about it. It did, and I mean that's kind of scary. That's kind of scary to think that any kind of app that you have, I guess that's why they ask you about the location services. Because any app that you do, whether it be Snapchat, whether it be any of these, they ask you about location services. So if you are just going through there and say only when I'm using it or whatever, that's when it starts kind of docking your location. Thank you, Kathy, so much for being here. We hope you do come back. And we will definitely be in yours whenever we see you on. Thank you so much. Be safe out there. So that's something for us to be looking into for sure, because it's always interesting to learn different things. And this seems to be a hot topic at the moment. This individual that's talking about this. I would have never thought that, but Spotify does it, Snapchat does it, TikTok, X, all of them. They all track your location. And especially if you have a running app, it's running in the background. And it's also like your health stuff. If you had an Android, I don't know about the iPhone because I don't have one. But as far as the health tracker, it's tracking you all the time. So the phone, as far as I understand, it could be off, and it's still, when you turn the phone on, you still have accumulated all those steps. It kind of resets itself to give you all those steps that you had while you were off the grid. But just something to think about. Yeah, I mean, pretty much we're being tracked everywhere we go, everything we do. It's kind of scary if you ask me. But at the same time, it does solve a lot of crimes. So half in one, half in the other, you know. Jeff, are you going live today? Are your company there? I'm about ready to hop off here. I'm gonna hit the gym. I hope you guys I hope you guys enjoyed this. And I hope that you have an awesome rest of your weekend. Because it's almost over again. I mean, it just comes and goes. Maestro, cue that music.